Hello, everyone, and welcome to Business or Pleasure Advanced B Visa Visitor Visas and the Visa Waiver Program. Thank you all for attending. This is Joseph Shepard from our Santa Monica office, and I'm joined by Adam from our New York office. Adam, can you hear me?
I can. Thanks, everyone, for attending. And we are going to present today a hopefully informative and perhaps lively presentation on the Visa Waiver Program, also known as ESTA, and B Visitor Visa Program. And there are a significant number of attendees to the presentation this afternoon. So we'll be taking a limited number of questions at the end. You are allowed to submit those questions via the online question submission form on the right-hand side of your screen. And we will only have the ability to get to a few of those. So thanks in advance for that, and you can email us separately and privately at the end of the presentation with any questions that you may have. So without further delay, we are going to go ahead. We will start with a brief overview of the program, and then we'll get into the nitty-gritty. So the Visa Waiver Program, is also known as the Electronic System for Travel Authorization. We will shorthand that as ESTA throughout the entire presentation. And the program authorizes travel to the United States for citizens of qualifying countries. And there's a list of qualifying countries that we will provide. It can also be Googled online fairly easily. Taiwan is the newest addition to the Visa Waiver Program list of countries. And the Visa Waiver Program is simply a program that allows foreign nationals to enter the United States who register through the ESTA program to come to the United States for business or pleasure for a period of up to 90 days without first obtaining a visa. And just so that people are aware, a visa is just a document that the U.S. government issues that permits you to travel to and enter the United States. So the Visa Waiver Program does exactly that, and it waives your requirements of first obtaining a visa to come to the United States. You are not allowed to remain permanently in the United States for, I think we're having a little bit of technical difficulty here. There we go. So you're not allowed to come to the United States for more than 90 days on the Visa Waiver Program. You have to have a valid passport in order to be eligible to engage in the Visa Waiver Program, and that passport must be machine readable. And if you have questions about what a machine readable passport is, that information is also readily available on the Department of State website or through using our friend Google. When you arrive on the Visa Waiver Program, you must do so through a signatory carrier, which is an airline or a passenger ship that is pre-registered. Most of the majority major airlines that travel to the United States are going to be signatory carriers, so you probably won't have to worry about that. If you have any questions, that information is also available on the Department of State website. And the simplest thing to do is to call your airline to see if they are registered. In order to be eligible for the Visa Waiver Program, you must have an intent to depart the United States, which also means that you must have a return or onward ticket from the United States, and that does not include a ticket to a contiguous territory of the United States, meaning Canada or Mexico, or an adjacent island in the Caribbean or the Bahamas. All right. And for those of you who have never used ESTA, the perks of ESTA are that it's fairly straightforward. It's simple to use. Typically, you won't need the services of us or any other attorney in order to travel on ESTA. It's a $14 application fee, which for anybody who's applied for a visa will feel really cheap because the visas are, can be $160, $190, and they go up from there depending on the country that you're coming from and reciprocity tables with the United States. There are very few restrictions on your travel under the Visa Waiver Program or ESTA, and as long as you're coming for business or pleasure and you don't intend on engaging in any productive employment for business purposes, then you're good to go under the ESTA program. The additional perk to ESTA that is different than most employment-based visas is that they're not tied to a specific employer, and they're not employment specific. There's no annotation on an ESTA entry like you may get with a B visa that we'll cover in a later slide. And so they're very versatile. It's a very versatile entry to the United States. All right. And just a brief overview on the B1 or B2 visa in contrast to the visa waiver or ESTA program. So a visa, again, is a formal, it's now, we refer to it as a stamp, but it's more of a sticker now that you'll get in your passport that allows you to board a plane and enter and come to the United States. The visitor's visa is a non-immigrant, the B1 or B2 visa is non-immigrant in nature, in that you cannot intend to permanently remain in the United States, and you cannot in any way have that intent upon the issuance or admission under the B visa. There are different kinds of Bs that we will cover in depth, but an overview broadly is the B1 is for pleasure or touristic purposes. The B2 is for, excuse me, I got that backwards. The B1 is for business. The B2 is for pleasure or touristic purposes. And you can also get a combination of a B1, B2 if you say, I'm going for a meeting for my corporation that's sending me for this particular meeting, and afterwards I really want to check out the Grand Canyon, something like that. All right, and you can also get visitors visas for very specific reasons, as opposed to the general reason of just coming for tourism. You can come to the United States on a B visa to seek medical treatment. You can come to confer with legal counsel. To some extent, you can come to, to visit a school that you're thinking about attending. You can participate in amateur sporting events, and the yoga class is sort of my classic example, but it could be a cooking class or any other class that's not degree-oriented. You can also come to the United States for that explicit purpose. All right, and you've heard me talk about non-immigrant intent. We're going to spend a little bit of time with the concept of non-immigrant intent, because that's going to pervade our entire conversation about the ESTA travel and admission to the United States on a B visa. So just in terms of the high altitude perspective on non-immigrant intent, you want to contrast non-immigrant intent to immigrant intent. And it's pretty straightforward. It's a bit self-defining. Non-immigrant intent is when you don't intend to remain permanently in the United States. That's the most simple and straightforward definition, and it gets very complex from there. Immigrant intent is when you do intend to permanently reside in the United States, and that's if you intend on getting a green card, essentially. So for all non-immigrant visas, you are required to have non-immigrant intent. That includes all travel under the visa waiver program and B1, B2, and B1 and B2 visas. Now for a little bit more in-depth on non-immigrant intent. So we've broken this up into ESTA and B1, B2 for the purposes of clarification, because they have different operational rules. But for both ESTA travel and for B1, B2 entries to the United States, you're not allowed to have immigrant intent. So you can take a look at these bullet points and think of them as the operational aspects of your travel, but do remember that you are not allowed to have non-immigrant intent, both under ESTA travel and under B1, B2 travel. So in terms of the operational aspects of the ESTA program, all ESTA travel is limited to 90 days. You will be required to leave the United States within the 90-day period. Otherwise, you will be permanently barred from using ESTA in the future, and you will require, even if you're from a list of countries that permits ESTA travel, you will need to disclose that you've overstayed your ESTA travel, and more likely than not, you'll be denied use under the ESTA program in the future, which would require you to get a B1 or a B2 visa for any further touristic or business-related travel to the United States. You would also need to declare on your non-immigrant application form, Form DS-160, that you applied through the consulate in order to obtain the visa, that you have overstayed your ESTA entry. And that's something that you should try and avoid. So if ever you enter on ESTA, please be mindful of the 90-day rule, please depart the United States before 90 days. And if you want to come again, you can always apply for additional ESTA entry. But as a cardinal rule, you should not remain beyond the 90 days under the ESTA program. The B1, B2 program is a little bit more flexible in terms of the length of period that you can stay. B1, B2s can be issued also for a long period of time. Many of them are issued for 10-year multiple entries. And you can remain in the United States typically for a longer period of time. The period of permission to remain in the United States is governed by the I-94 card when you enter on a B1 or a B2 visa, and we'll cover that in more detail in future slides. But essentially, they're often issued for 90, 160 days, 180-day periods, and up to a year period, depending on the purpose of your trip to the United States. So you are allowed to have longer-term stays, and you're allowed to do all sorts of things under those under the B1 and B2 visa. We have made a notation of the 30 and 60-day rule here, and visiting family members in the United States, because those are in fact, all of these bullet points from 30 to 60 day down can be considered red flags for B1, B2 travel. They're things that you should be aware of if you intend on changing your status, which we'll cover in greater detail in the future, within 30 or 60 days. If you have a series of multiple entries under the B1, B2, let's say you're issued a 10-year visa and you're coming in every 6 months for a multi-year period, that starts to raise flags. If you're issued a 160-day visa and you're staying for 150 of those days, and then you go out and then you come back in and you're issued another 160-day entry and you're staying for 159 of that, again, that's starting to raise red flags. And anytime you're visiting family members in the United States, it is permitted, but it's going to be treated with a greater degree of caution because the admission officer, the Customs and Border Patrol officer, will be wary that you'll remain in the United States with that U.S. family member, U.S.-based family member. So those are just some key red flags to be aware of, but again, we'll discuss a lot of those in greater detail in the future slides. All right, and so again, we're going to spend a little bit of time on immigrant intent, which you're not allowed to have when you're traveling under the ESTA program and under the B1, B2 visa program. So in order to overcome immigrant intent, because it can be explicit or it can be inferred, we've listed what we're calling the guiding principles to overcome immigrant intent. So you should seek to limit the duration of time in the United States where possible. If you're issued an I-94 card that permits you to stay for a year, if you don't have to stay for that full year, that's probably a good thing. If you purchase a return ticket home and you travel with that return ticket home and you present that to the CBP admission officer, that's also going to be favorable for overcoming immigrant intent. If you can demonstrate family ties to a home country, that's also going to help you overcome immigrant intent. And family ties are weighted differently according to which family members are in the home country. If they're spouse or children, those family ties will be considered of greater value or greater weight in terms of overcoming immigrant intent than if you're an adult and you have adult parents in the home country or brothers and sisters. Those are weighted less heavily than spouses and or children. For individuals who have same-sex spouses, that issue becomes a little bit more complicated. We'll discuss that in detail in further slides, but because of the Defense of Marriage Act, which is current law in the U.S., despite the challenges to it pending before the Supreme Court, and the ability to get married in the United States in several jurisdictions for same-sex couples now, it does remain a complicated question, which we will cover in greater detail at a future time in this presentation. And assets in the home country are another good way to overcome immigrant intent. So we're often asked the question of what are sufficient assets, and unfortunately there's no great answer to that. The more assets, the better. Property ownership is weighted heavily in terms of overcoming immigrant intent. If you have significant bank accounts, since money is so fungible, or at least we think of it that way, that's less heavily weighted than property ownership. But assets in the home country are a good way to overcome immigrant intent. And you will need to demonstrate that you have adequate funds to return to your home country in order to be able to overcome immigrant intent as well, which is why we've added that bit to this slide as well. And then, number 5, the principal purpose of the visit must be to engage in lawful business or pleasure activities. That's really the story for all visas, is that when you're issued a visa, you should be traveling, or you should be coming to the United States in accordance with the principal purpose of that visa. So for a B2 or a B1, if it's a B1, the principal purpose should be business-related, and B2, the principal purpose should be pleasure or touristic or tourism. And if it's another non-immigrant visa, it should be that visa that you get. All right, and then just to highlight some issues that may come up when you're filling out the ESTA application form and when you're applying for a B1 or a B2 visa through the online DS-160 form. If you have a criminal conviction in your past or an arrest in your past, you will be asked about that. This is the time when you should pick up the phone and call an attorney. The nature of arrests and criminal convictions are very complicated under U.S. immigration law. What may be considered a simple violation, or if you're in the UK, a simple police caution, can be considered just a slap on the wrist in terms of domestic, domestic criminal considerations. But for the purposes of U.S. immigration law, they can be quite serious, and they can bar you from admission to the United States. We highlight a few of the categories here that serve as principal barriers to admission, but there are waivers that are available to these, and there are ways that we can strategize with you to make sure that if you do have such an issue, that you will be granted admission to the United States. Crimes involving moral turpitude is a purposefully vague and nebulous definition of crimes that the U.S. government, the Board of Immigration Appeals specifically, has really not sought to define. The U.S. Congress has never defined. But essentially, it's crimes that are base or inherently vile in their nature. It often includes crimes of theft, assault, and other such crimes can be considered crimes involving moral turpitude, as can a wide range of crimes. So if you do have any arrest or any conviction in your history, I would strongly urge you to consider consulting with an immigration attorney before you submit your ESTA form or before you submit your online DS-160 form, because either failure to report an arrest or the reporting of an arrest can seriously impact your ability to come to the United States. Controlled substance violations is also another big category, and this includes marijuana and cannabis arrests. So oftentimes marijuana arrests are considered minor violations in foreign jurisdictions, and in certain places in the United States have now been decriminalized. But if you have such a conviction, there's a specific subset of laws that apply to you, and they apply rather harshly. So it is very important, if you do have any criminal convictions, again, I just strongly urge you to consider contacting an attorney, because it's going to be a little bit more difficult than you might otherwise think. Fraud or misrepresentation. This essentially means when you misrepresent yourself either intentionally or unintentionally on any form to the U.S. government. Where we see this most frequently occurring is when somebody fails to report a prior arrest or prior criminal history under the ESTA program when they enter under ESTA, specifically for those living in the UK or on the phone from the UK. police cautions are required to be reported for ESTA entries. Many times people think that they're minor violations and that they're a sort of slap on the wrist and they're not required to be reported, but they are. And in the U.S., if you have had, it's in New York, we call them ACDs, but it's an acquittal, in contemplation of dismissal. Then those are required to be reported as well. They may not remain on your permanent record, but that doesn't mean that you don't need to report them for immigration for immigration purposes. And the other two areas that we often see are visa overstays. So that's if you've overstayed your admission to the United States and your I-94 card by a period of either 180 days, well, any days really, but serious bars kick in after 180 days in 1 year in 3- and 10-year bars, and any health-related disabilities that may arise, including tuberculosis and previously including HIV and other communicable diseases of public health significance.
I'd like to add as well for the prior overstays, often the case may be where someone on a B1 or a B2 visa overstays a period on the I-94 record and attempts to then come back in using the same visa. However, INA 222G prohibits the use of that visa again because the visa is automatically invalidated, requiring them to apply for a new B1, B2 visa if that's the purpose of their next entry before they can come back in. While it can't magically turn itself into saying canceled on it, it is automatically invalidated. So if someone overstays a period of stay authorized, they need to apply for a new B1, B2 visa before they can come back in that same category.
Thanks, Joseph. That's a great addition too, because the B visa is, issued oftentimes for a 10-year period, and people think that it remains valid for that 10-year period. But yes, that cancellation is automatic, and that's a very good point to make. All right, and you've probably heard us refer to these terms in passing, and now we're just going to cover a brief overview of what they explicitly mean. So admission is the process by which an individual who's coming to the United States and obtained a visa or travels under the ESTA program is officially permitted to enter the United States at a U.S. port of entry. So this is when you will be inspected by a Customs and Border Patrol agent, when you have to wait in that vicious, often line at the airports, or if you're on a cruise ship at a port of entry. And you'll be asked a series of questions about why you're coming to the United States. And this is where you'll have to pass sort of a second hurdle if you're traveling under a visa. And if you're traveling under the visa waiver program, or if you're a Canadian citizen and you're not required to have a visa, this is essentially where all the work will occur. And that's in front of a Customs and Border Patrol agent. A visa. Sorry, Joseph, did you want to jump in?
Oh, no, sorry, go ahead.
All right, so an extension of status refers to the continuation of the same visa status that was previously held by the individual who is now seeking to remain in the United States. There is a very, very limited exception for an extension of the 90-day stay under the visa waiver program, or ESTA, essentially for medical emergencies for an additional 30-day period. In order to obtain that, you will need to have the discretionary approval of a USCIS director, and they're rather difficult to obtain. So you should just consider the 90-day period as a hard and fast limit. But if you have a medical emergency and you can't depart within the 90 days, there is a one-time 30-day extension that's permitted under ESTA. The B visa program is much more flexible, actually. You can apply for an extension of that status of the B visa entry with the form I-539. That form is then processed internally in USCIS processing center, and if the period of stay that has been authorized has expired, so you're required to submit the extension before the period of authorized stay expires. but if it expires in the processing time, then the extension of stay is granted. It will be backdated so that there is no gap in the authorized period of stay. But the key here to remember is that the extension of status must be applied for before the expiration of your current authorized stay under the B1 or B2 visa. Okay? And then finally, we come to a change of status. And a change of status is a term of art that describes going from one visa category to another visa category. So that would be if you were going from either a B1, B2 visa to, let's say, a student visa, also known as an F visa, or if you were switching from, and we will cover this in greater length in future slides, if you're going from a B1 or B2 visa to an immigrant visa, like a green card, through the I-130 or I-140 sponsorship process. And so that is referred to as a change of status because you are changing from one visa category to another rather than extending, which again is the same visa category. All right. And ESTA admission. So just to briefly just make this explicit, I think we covered this in our previous discussion in the previous slide, but those traveling under ESTA will still need to be inspected by a Customs and Border Patrol agent, and so this is where the issue of non-immigrant intent may arise, and this is where you want to be careful about what you're saying and the purpose of your travel to a Customs and Border Patrol agent, because they are allowed to infer immigrant intent based on what you say, even though you may not explicitly say, I'm coming to remain in the United States. Also, an applicant for admission through ESTA or the Visa Waiver Program, because they're inspected, they will be issued what's called an I-94 card. And the I-94 card is a little, paper card that's often stapled into your passport and governs your period of admission into the United States. We have a little asterisk here because the Customs and Border Patrol agency has declared that they are going digital, and the I-94 cards will no longer be issued in paper form as of May 21st, 2013, so coming up in 20 days. Where there's very little guidance as to how this is going to work, and I think it's causing a lot of consternation in the visa world because we're very familiar with the I-94 card, and people are just sort of used to having it, and it's required for a lot of forms that we need, and it will no longer be issued in paper form. Theoretically, it will be a simpler process. It will be electronic-based, and you will be able to look up that number in an online system, and it will be a seamless transition. It's a little bit difficult to believe that that's going to be the case, but that's what we're told, and so that's what we're reporting. And in that case, ESTA entrants will no longer, as will all entrants, no longer receive an I-94 card, and it will be available online. All right. So now that we've covered extension of status and change of status, and now that we've covered entries under the ESTA program, we are going to delve into what is permitted under ESTA entries, because an ESTA entry is specific and unique, and it is very different from a visa entry. I think the slide is fairly straightforward here, but the principal thing to keep in mind is that changes of status and extensions of status are not permitted under the Visa Waiver Program. So it's a very limited program. When you enter under the Visa Waiver Program, you waive all sorts of rights. You waive your rights to appear in front of an immigration judge. You permit expedited removal of yourself from the United States, and you're not permitted to extend or change that status. We've noted the exception that I mentioned earlier in case of emergency, particularly medical emergency, but the governing rule with an ESTA entry is that you are required to leave within the 90-day period, and if you abuse that privilege, you lose that privilege. All right, now to contrast, because the ESTA program is so unique, we certainly wanted to advise as to its peculiarities. In In contrast to the ESTA program is an entry under the B visa program. And again, when you're issued a B visa, that's explicit authority to board a plane and to come to the United States. And so once you have gone through the process of obtaining an interview, going to that interview at the U.S. consulate abroad, submitting the online form, going through the interview, and then being issued the visa, then and only then you are allowed to come to the United States on the B visa. As with an ESTA entry on a B visa, you will be inspected by a Customs and Border Patrol agent upon your touchdown in the United States. You should be prepared to re-demonstrate your eligibility under core B visa requirements, and I can't I can't sort of underline that enough, and I didn't really underline it here, so I guess I just wanted to reiterate it verbally that often people think that because you've been issued the B visa that you don't have a problem with immigrant intent at the border, or that they're one and the same. And it's very important to keep in mind that they're two very separate and very sort of idiosyncratic interview processes. So the U.S. consulates may ask you specific questions about your travel, and the Customs and Border Patrol agent may ask you very specific questions about your travel. They may even be the same questions, and they can come to two very entirely different conclusions. So you should be aware of that. They are unique, they are idiosyncratic, and you will need to make sure that you are not demonstrating principally immigrant intent in order to be admitted to the United States on a B visa, both at the consulate when being issued the visa and upon inspection by a Customs and Border Patrol agent. We've already covered that the B visas can be issued for a multi-year period. It can be 3, 6, 10-year period. And then the I-94 card governs the actual period that you're authorized to remain in the United States under that entry. And the I-94 card itself can be issued for 90 days, 160 days, 180 days, and in some cases for a 365-day period. That's pretty much the limit of the of one entry under the B visa. And so if you need longer than a 1-year period, you can either pursue that through multiple entries, or you can pursue that through a different visa category. Okay, and unlike the ESTA program or the Visa Waiver program, you are allowed to extend your status and change your status from a B visa. So it's a much more flexible option for those who are coming to the United States. The extension of status is accomplished through the submission of the Form I-539. That's done at a U.S.-based processing center. The typical centers are in Vermont and California. At least those are the ones that we work most closely with. And you can extend for increments of up to 6 months. Again, and I highlighted it here, but the takeaway from this particular slide is that an extension of status must be filed for before the expiration of the current. It says your previous B status, but the status that you're on, that you enter in, you have to apply for the extension before that one expires. Okay, and a B visitor also has the ability to change to most other non-immigrant statuses, so long as you're not violating your status in doing so. And you, again, have to timely file for that change of status, which means that you have to file for the change of status before the expiration of the B status. Again, the 30 and 60-day rule applies. We will cover that again in greater detail, but essentially, if you change your status from non-immigrant to immigrant status within 30 days, the USCIS is allowed to presume improper intent, meaning that you said that you wanted to come for a non-immigrant purpose to the United States, but within 30 days you've now expressed an intent to remain in the United States for an immigrant purpose. And so they are allowed within a 30-day period, if the change of status is done within that 30-day period, to presume improper intent. If you do it if you change your status from non-immigrant to immigrant within a 60-day period, they can again infer improper intent, but typically they'll do so where there might be other indications of immigrant intent, and other indications of immigrant intent can be inferred on a number of different grounds. We'll cover some of those later. But principally that's, if you're pursuing a green card, things like that, essentially that's when they'll infer improper intent. Okay, and then just to recap, this is a lot of information that we're throwing at you, and it's going to get more dense from here, so we're going to try and provide a little bit of recap as we go along, just to refresh and to keep this all in your memories. So ESTA, inspection is required upon admission under the ESTA program. The admission is for a 90-day period, no extension of status, and no change of status. Again, there is that limited exception for extension of status under the ESTA program for dire medical emergency, but for all intents and purposes, no extension of status and no change of status are the rules that govern the ESTA program. The B visa program is more flexible. Inspection upon admission is still required. The B visa the B visa can be issued for a multiple year period, up to 10 years, but the actual period that you're permitted to remain in the United States is governed by the I-94 card and is often issued for a 90, 180, or 365-day period. A 1-year entry is the cap on a B visa, and extension of status requests and change of status requests are permitted by a B visa, keeping in mind the 30 and 60-day governing rule. Okay, and you've heard me talk about briefly adjustment of status. We're going to go into that in greater detail, and for the sake of this dialogue, we just wanted to provide a definition of adjustment of status because it is a very specific term of art. It makes no sense unless you know what we're talking about. And so adjustment of status refers to the process by which an individual who entered in a non-immigrant purpose to the United States wishes to alter their status to that of an immigrant purpose. And again, a non-immigrant purpose would be with a mind on leaving the United States, and an immigrant purpose would be with a mind on remaining in the United States. The ways the immigrant visas that are issued are through the I-130, which is a form where it's called an alien relative, and pardon the term, petitions on your behalf, and that's known as the family-based green card, or an I-140, which is the employment corollary to the family-based green card. Okay, and then in terms of, so we went over extensions of status and changes of status, and now we're going to talk about adjustment of status under the ESTA program and the B visa program. So the guiding principle for ESTA entries is that you can't adjust your status when you enter under the ESTA program. There are limited circumstances for family-based immediate relative I-130 petitions. If you think that you're in that category, you should certainly talk to an attorney about whether or not you're eligible to adjust your status. But the exception are for immediate relatives, which is principally a spouse, and family-based petition. And again, it's subject to the 30-60-day rule of intent that we covered earlier. But just to recap, within any adjustment of status under the ESTA program within 30 days, the USCIS is allowed to presume improper intent. And if that adjustment of status occurs, within a 60-day period, then that improper intent may also be inferred. Although it may, in order for that to be triggered, you may need some other indication of immigrant intent. So to contrast ESTA with the B visa program, adjustment of status is permitted for I-130 and I-140 adjustments. If the person is in status. If they're out of status, that's also permitted, but that's something that you need to be careful about, particularly because it's only permitted in the I-130 immediate relative adjustments. So that's something, again, that's a little bit tricky. You probably want to contact an attorney at that point if you've fallen out of status. And the adjustment of status.
Sorry, Adam. I wanted to just
Yeah.
jump in, and Adam and I talked about this beforehand, and we wanted to just, make the comparison fairly clear with the difference between being able to adjust in most cases versus entering on a B or entering through ESTA. While it may be technically possible to file something, maybe an immigrant petition and a concurrent adjustment for a foreign national who entered with ESTA, practically, even in those situations, with the 30-60-day rule in play and the 90-day limitation on their stay, and the rule that one maintain their underlying non-immigrant status throughout up until the time that they actually adjust a green card holder, it becomes pretty much practically impossible to do so with an I-140 in those limited circumstances under ESTA. So, in general, it's just not an option. So I just wanted to, make that clear versus the B where, you can extend your B or you can change your B to something else, which, would maintain the underlying non-immigrant status, be enough time, past which one could reasonably expect an adjustment of status application to be approved. So, it's a pretty important distinction between the two of what is allowed and what's not allowed. ESTA was enacted with the goal of facilitating short-term travel between countries with which we have close relations, but not to allow them to, become immigrants. Just an aside.
Great. Yeah. No. So that's a good point of clarification, and it serves. I think it serves to show the importance of keeping in mind what's permissible and what's operationally feasible. And oftentimes you'll run into those questions when applying for visas is what is actually permitted under law, and based on the timing and the actual I-94 that you're given and all of those things, whether or not functionally you can have your your petition submitted, processed, and approved within that time period. So, and in certain cases, whether or not it will be deemed valid upon submission or receipt, or whether it will be deemed valid upon approval. So this is where the intricacies of immigration law get a little bit, get quite complex, and at that point, again, it's probably best to seek outside counsel or our advice. But again, this is intended to provide an overview of the process, and then we're going to get a little bit more detailed into the weeds in terms of permissible business activities. And here we go. So, this section is called the business traveler because we presume that that's what the majority of you have come to this presentation for, but we thought it was good to give you a sort of high altitude overview of what it means to travel to the United States, the limitations on travel to the United States under the ESTA program and the B visa program, and the ability to move out of those programs into other immigrant categories. The rest of the presentation, we're going to spend a little bit of a detailed time on what it means to be a business traveler to the United States. This area of law is rather specific and rather complicated, and as you will see, often is defined by the negative. So we tried to provide you where possible with generalities, but please keep in mind that there are exceptions to these generalities for most cases, and we will cover those where we can, and we will tell you where there's been no guidance where we can, and in some areas there's just very little or no guidance, and it's up to the discretion of particular CBP agents or consular officials, and we will also tell you that where that occurs. So, for business travelers, the general principle and the general thing to keep in mind is highlighted in blue here, that and the key terminology is productive employment. So no productive employment is permitted under either the Visa Waiver Program, also known as ESTA, or the B Visa Program. They are for business travel and tourism travel, and not to engage in productive employment. The rest of the presentation will be spent on defining what that means. Okay, so here are a list of some permissible activities, and these have gone through the appeals process. They've been cleared with advisory opinions, and so we can fairly straightforwardly say that these things are permissible. Of course, there's an exception to every rule and an exception to that exception when it comes to business, traveling, and what's productive employment. But for the most part, negotiating contracts, consulting with business associates, attending conferences, engaging in commercial transactions that don't involve in gainful employment, and collecting information in preparation for productive employment are permissible activities. So negotiating contracts is fairly straightforward. Consulting with business associates gets a little bit more tricky. What we mean by the generality is if you're coming to the United States essentially for business meetings, you can do that. If you're a consultant and it's your job to consult, that's probably impermissible, and we'll cover that later. But depending on the consulting and what you do for your principal employment, consulting is a bit of a slippery term, but think of this as going to meetings with associates. You can do that. You can attend meetings and you can attend conferences. You can engage in commercial transactions, meaning you can buy sandwiches, you can purchase goods, like if you're going shopping and you want to buy shoes or a handbag, you can do that certainly. When you're selling those things, that's impermissible. And if you're collecting information in preparation for productive employment is a very specific case that we'll cover later. But the classic example is if you're a tailor and you're coming to the United States to take measurements, or if you're a cobbler and you're coming to the United States to take someone's shoe size, you can then return to your home country and make the suit or make the shoes. And so if you need to be in the United States to do that activity, to collect the information, you can do that and then go abroad to do the actual work. I think a more modern example would be a website designer or a graphic designer. If they wanted to come to the United States to meet with their clients to assess their needs for a website overhaul or for a design project, they can attend meetings, they can engage in services to gather that information required, but the actual production work would need to happen abroad. Okay, and here's a somewhat straightforward list of impermissible activities just to contrast with permissible activities. So providing pay-for-fee services is a very broad and general way to say, let's say you're coming to the United States and you're, I don't know, you're a vendor, so if you're coming for, if you sell ice skates, for example, the hockey playoffs start today. And if you're selling skates in the United States, that's a fee-for-service arrangement, and you cannot do that. If you're a consultant or a counselor and you're providing those consulting or counseling services for fees, and that's your principal employment, you cannot do that. If you are carrying out the terms of a contract, so you can engage in contract negotiations, that's permissible, but if you're carrying out the terms of a contract, if your contract, say, was, to provide, roofing or insulation on a home project, a home renovation project, you cannot carry out the terms of those contracts in the United States. If you're, let's say you're doing, some reporting, you can come to the United States to collect information, but you can't do the actual, let's say you're doing competitive intelligence reporting, for example. You can come to the United States and gather all the information that you want. You cannot do the productive employment of actually preparing the reports and preparing the competitive intelligence analysis in the United States. And I think we've covered, I think my example already sort of covered building or construction activities, but again, that's an example of what is not permitted under the B visa program. And again, just to reiterate, and we will probably constantly do this, but this is a very difficult area of the law. It's rather subjective, and there's often very little guidance. So there's a lot of gray areas that we will cover, and I think I'm now turning it over to my colleague to cover some of the more explicit areas that are permitted, but please keep in mind that there's a lot of gray area in this law, and we hope to clarify it for you, but it's impossible to clarify entirely.
Thank you, Adam, and that's a very good point. It's entirely a very broad area of the law, and that has very few but important distinctions. And by saying very few, I mean very few instances where something that borders on productive employment would not be something that's not allowed under the program. You know, we said very clearly and put in very bright, bold letters, no productive employment is permitted under ESTA or the B1 visa waiver program, or excuse me, B visa program. And then, of course, there's the exceptions. You know, we will go into detail into the types of permissible business activities that, in the gray scale of things, may seem to be approaching productive employment, but the reasoning behind their being allowed will be explained in detail. For example, the B1 in lieu of H1B, or the B1 in lieu of H3, the B1 that's similar to a TN, the NAFTA B1 differences, and the domestic employees of certain U.S. citizens who live abroad, or domestic servants or employees of non-immigrant visitors. So there was a case Adam mentioned before of the tailor, and this was matter of Hira back in the 60s, who came to the U.S. to take some measurements for some suits that were going to be manufactured and shipped from outside the U.S. to clients within the U.S. This was determined to be an appropriate B1 business activity because the hands-on productive employment and the company's place of business were both outside of the U.S. So the accrual of profits, the principal place of business, and the actual place of manufacture were outside of the U.S. The person was coming to the U.S. simply to meet with potential clients and get the measurements needed in order to do the actual work, the actual hands-on productive employment outside of the U.S. The other example was the cobbler, and I think these are great, traditional examples of the types of business activities that would be allowed in the U.S. And then trying to translate that into the 21st century can take a few different turns. Meeting with potential clients for website design, if the design were to be done predominantly outside of the U.S. by a company outside of the U.S., and the individual coming to the U.S. to do so was employed customarily by that person outside of the U.S. So, what we've done is gone through the different classifications or subclassifications of permissible business activities that are allowed, and go into some detail exploring what those are and what would be required to obtain such classification. The specifics of the ones enumerated in the Foreign Affairs Manual, the FAM, are listed in the Chapter 4131, Notes 8 through 11, for those of you with access or interest in the FAM and the types of B1 activities that are explicitly permitted. The Department of State also maintains on its website a nice kind of central area called the Business Visa Center that assists U.S. companies in trying to determine what is acceptable and what's not acceptable, listing by purpose of travel and then the specifics of each visit, what is a permissible business activity. For example, lectures or speakers, we went over with some generality of what would be allowed, and we'll go into more detail here, but, discerning between a professor who's visiting a university to give a speech versus someone coming to a conference about hydraulic drilling, per se, which one would be allowed to receive money and what kind of money they could receive. It will be explored in more detail. So just to summarize that point, you know, people that are coming to the U.S. to engage in commercial transactions. Let me just change the slide. So we went over this with some detail before, but here we go again. You know, to come to the U.S. to engage in commercial transactions which do not involve the hands-on productive employment in the U.S. Is permissible. To negotiate contracts, specifically, for example, individuals who plan on eventually perhaps opening a branch office in the U.S. Some individual of the company based abroad may be able to come to the U.S. to negotiate, say, the lease contract or a future contract between the two entities, or perhaps negotiate an employment contract or a record company contract. To come in to consult with business associates, to basically the very basic one is to come in for meetings. They're coming in for maybe a week-long session of meetings. Maybe it's about a specific product. Maybe that product is manufactured in the U.S., but the person coming for the meeting is based abroad and will be using that product in their office, say in Holland or Australia. You can also come into the U.S. and be one for litigation if you are a party to the litigation, or if you are not intentionally a party to the litigation, but you've been subpoenaed or you're being called as a witness. You can come in for those purposes. You can also come in, like I said, for the conventions, conferences, or seminars. If you are a visiting professor from abroad and you will come to the U.S. For, say, a guest lecture or something else, you are allowed to do so in B1. If you, in the past 6 months, have not received more than, I believe, 5 honorarium payments for those visits, then you're within the classification still of B1. If you're coming in to speak at an annual conference, as long as you're not receiving remuneration from a U.S. source other than maybe repayment for your typical expenses, then you're fine. And then, of course, the kind of ambiguous undertake independent research. Some individuals have attempted to come in to do independent research instead of obtaining the proper, say it's a J1 or an F1 visa. Independent research is more akin to non-affiliated with a traditional academic program. So if you're coming in to do an independent research project that's perhaps based outside of the U.S., the primary area of your research is outside of the U.S., perhaps at a foreign university, and you need access to perhaps maybe 30 days of the library of a sister university or college, or you're coming in to perform perhaps research into opening up the new office of a company or new investment enterprise. Those are the types of independent research that are permissible under this category. So as you can see, these are types of things that are rather incidental to the professional business activities in their home country, and even more specific than just these general categories. There are some subcategories that are extremely specific, and these are next going to be the ones that are very close to productive employment, and in fact some of them are so close that USCIS requires, in addition to being here in B1 status, applying for employment authorization. Specifically, the fourth bullet point on this list are the infamous, I guess I would say, they're very difficult and tricky types of B1 classifications. The personal or domestic employees. This is traditionally for individuals who have worked for a U.S. citizen who resides abroad. You usually have to demonstrate that you, if you're the domestic or a personal employee, have had a working relationship with the U.S. citizen for at least a year. If the U.S. citizen is just temporarily assigned outside of the U.S., perhaps they're on the equivalent of a non-immigrant visa in another country, and they are working for you in that, and you are working for that U.S. citizen in that foreign country, and you've done so for more than a year, but the U.S. citizen may need to come back to the U.S. for some specific purpose. They obviously don't need a visa, but you, as the domestic employee or personal employee, would. And one particular way you can accompany the U.S. citizen who's returning to the U.S. is to obtain a B1, B2 visa specifically and enter in the B1 category. However, and we'll go through in particular the types of evidence you may need whenever applying for the visa and for entering the U.S. later, but it's important to note that you cannot work actually in the U.S. until you acquire the employment authorization document. Now, this is one of the only areas of B1s that allow for employment authorization documents, but also require them in order to carry out any of the activities that are allowed. So until you acquire that EAD, then the implication is, because there's not a formal guidance available on this, you are not, and this is a conservative viewpoint, but for those of you familiar with Adam and I, we like to take the conservative viewpoint on anything that could potentially put people in jeopardy or at risk for immigration violations. You cannot work until you receive the employment authorization document. Procedurally, those can take around 90 days to acquire. So if you enter in B1 status as a domestic employee of a U.S. citizen who resides abroad or who is temporarily assigned abroad but is coming back to the U.S. for a specific purpose for a specific length of time, keeping in mind that you're granted 6 months max. Usually, sometimes you can try to get a year, but more often than not, it's the 6 months. And you would apply then for the EAD, 90 days of which, while you're waiting, you cannot actually be performing the work. If you have to remain in the U.S. beyond the 6 months that you were initially given, you can apply to extend your EAD once you receive it up to 120 days before the expiration date. But then there gets into the problem of, if the B1's expiring on a certain date, do you have to have the B1 approved before you can file the EAD for that same amount of time? The answer is maybe. You can try doing a concurrent filing of the 765 and the B2 extension. Sometimes they may be rejected because service centers are so unfamiliar with this subcategory of a very underused subcategory, to be frank. So, while you can try to do the concurrent filing, if one is rejected and you need to refile the 765, for example, you can do so with either the receipt notice for the B2 extension and request that upon approval it be approved for the same amount of time, or a copy of the filing that you made for the B2 extension along with that. For those of you who are interested in this very small subset, definitely seek out a qualified U.S. immigration attorney who is experienced with these types of visas. They can be very tricky, and there's a lot of specific requirements. I list 3 of them separated by semicolons here of the different subcategories of subcategories, and they're all slightly different. And in particular, those domestic or personal employees of foreign nationals in certain non-immigrant statuses, there's only some of the non-immigrant visa statuses that allow for the personal or domestic employees. And notably, I say here, but not of LPRs. And the reason being is that the implication of having LPR status or green card holder is that you reside in the U.S. So your home is in the U.S. Therefore, you're not residing abroad, and you're not just temporarily coming to the U.S. Your home is the U.S. So there would be no need for your personal or domestic employees to come with you. Moving on, and the professional athletes is another subcategory. Those who are coming into the U.S. for competitions. Usually they prefer the internationally recognized athlete category to be used, the P1 for this, especially if the person will be receiving payment for their appearances at the competition. However, they can enter in on B1 status as long as there's no payment to them other than the potential prize money. Prize money is not considered payment for their services for B1 professional athletes. We also have the intending investor. And this is a category often used by individuals seeking to eventually obtain or obtain for their employers E2 treaty investor status. Oftentimes for E2s, you have to demonstrate that there's a substantial investment into an actual and real operating enterprise in the U.S. You also have to show a number of other things, but those being so important, they don't happen overnight. So there has to be some legwork or groundwork done at the outset to actually say, like I mentioned before, negotiate the contracts for a lease or meet with the bankers with whom will service the accounts for the investment enterprise, or to talk with potential clients of the new enterprise in the U.S., or potentially to negotiate the purchase or sale of an existing enterprise. Those types of individuals who eventually seek to invest a substantial amount of money into a operating a real enterprise that they are going to be directing or managing, for example, can obtain B1 status as intending investors.
Can I
other types,
for a second, JJ?
Please.
I think, too, it's important to keep in mind for investors, for intending investors who are thinking about coming to the United States with an E2 visa, that you often have a chicken or an egg problem here, because you are required to have substantial operations in order to have the E2 issued, and oftentimes, you're not allowed to enter to set up those operations. But under the B2, you're not allowed to engage in productive employment. So, so this is where you really, if you are considering entering for intending investment purposes, this is where an area where I would strongly caution to consult an immigration attorney as well, who knows about the particulars of investment visas, because oftentimes you run into adjudicators who don't want to issue the B because there's the investor visa category, but you also can't get pre-clearance from a foreign consulate because the entity hasn't been established to sufficient degree for the E2 to issue. So you do have a bit of a chicken and an egg problem here with the B1 and the E2 visa in terms of the actual operations that are underway. So again, that's something that we can cover for private consultations in greater detail, but just be aware that that's a very fine line and a gray area when we're talking about investment visas. I'm turning it back to you.
Thank you very much, Adam. And just in the interest of time, I won't spend as much going over some of these, but I will say at least some about, for example, the next few categories. Certain after-sales services. If an individual is coming to the U.S. to perform certain very limited services or training for for example, perhaps a software product or an industrial product that is incidental, and by proving incidental to an international sale of goods is either specifically mentioned in that contract or can be established to be in maybe an accompanying contract that was made at the same time, and in addition to the contract for sale of goods, the goods must have been manufactured and came from outside of the U.S. This is similar to one of the types of additional business activities that are permitted under the wider umbrella of the NAFTA, the North American Free Trade Agreement business visitor category for Canadians and Mexicans, which I'll get to in just a second. But it's interesting to note that those types of things about maybe performing the after-sales services of a training pursuant to the sale of a certain type of perhaps heavy manufacturing equipment or machinery specific to that contract. And there are many more limitations that I'm not mentioning here in the interest of time, but those types of services, may be permitted for certain individuals in B1 status if all else is not possible. So again, speak with a qualified immigration attorney for those specifics. Certain non-remunerated artists and entertainers. So individuals coming to the U.S. to perform who will not be paid. Now, perform. If an artist is coming to the U.S. to perform on a stage, and that stage is a public venue or one in which people can buy tickets to, and they will be paid for that, as an example too, then the appropriate category is something else other than the B1. But if they're coming, for example, to perform just the recording for maybe a new album, and that album will be only distributed outside of the U.S., or they're coming in for a very limited purpose, then the B1 may be acceptable. Otherwise, the other appropriate categories may be the O1 or the subcategories of the P or the Q. For entertainers, certain individuals who are coming to the U.S. to perhaps compete in some sort of talent show, for example, or some kind of competition that they're not being paid for to come and participate in, but there may be some prize money, that may be okay. So the one classic example I'd like to give kind of as a small joke for that would be if someone was coming to perform on a extremely low budget game show, perhaps they were not being paid for to appear on, but there was a potential reward or prize for winning first place, something to that effect. Again, if you have a specific situation that requires looking into what the possibilities are, contact a qualified immigration attorney. I already talked about the honorarium payments for visiting academics, and I briefly mentioned the NAFTA business visitors. There are certain specific subcategories of that subcategory which are somewhat wider than those which would otherwise be allowed on the B1 for individuals. Canadians who don't traditionally need to acquire a visa for B1 can make an application for entry as a NAFTA business visitor at the border. Mexicans either require a B1 visa, or if they have a border crossing card, they can use the border crossing card together with their passport and evidence of qualifying under one of the subcategories to enter to perform some of the NAFTA B1 business activities. These include the after-sales services, but the after-sales services as listed under the NAFTA are particular to things that occur in the NAFTA region. Now, I don't want to get into too many splitting hairs with this very small subcategory, but if you have certain employees who may need to enter the U.S. from Canada or Mexico to perform perhaps after-sale services, or even in some very limited instances sales activities or research and design activities, very limited instances marketing activities, or distribution services. This includes very small possibilities of individuals leading tour groups, tourism personnel. For example, if the tour begins and terminates in another country, if it begins in the U.S. but terminates in another country, the tour must significantly occur in the foreign country. There's very, very specific things listed for each of these small areas. But again, if you have specific questions about NAFTA business visitors and the permissible wider and in some cases more restrictive subcategories, definitely contact one of us afterwards. And one that we often receive questions of, and especially after the H-1B cap was met in 5 days, is the very underutilized or misunderstood, I think, is the more appropriate way to describe the B1 in lieu of H1B, or the B1 in lieu of H3. H1Bs, for those who are not dealing with it on a day-to-day basis, like we certainly are specialty occupation visas, which are for individuals who are coming to work in a specialty occupation and are qualified for a specialty occupation. And then a specialty occupation, in turn, is one in which requires at least a bachelor's degree in a specific field of study, and the foreign national has to have that bachelor's degree in that specific field of study or a related field or the equivalent. And by equivalent, either foreign equivalent through a foreign degree evaluation, for example, or the equivalent through a combination of education, training, or experience. You know, the traditional use of the H-1B is for engineers, for accountants in some instances, for computer programmers, things like that. They've also been used for other types of specialty occupations, including market research analysts or other types of business subspecialty positions, not just requiring a bachelor's of administration, business administration, but perhaps in marketing, international business, business management, or accounting or finance. The H3 is a trainee visa, which is for individuals who are coming to the U.S. to undergo a formalized training program that will benefit them in their career potential or career search or just profession abroad. The training has to be unavailable in their home country, and the H3 program may not be used as a means by which to recruit foreign workers. So whenever the H-1B cap is met, and this is the first time it's been met in such a short amount of time since the start of the Great Recession, the B1 in lieu of H-1B may be a possibility. So let's say that there's a company that is somehow engaged in business with a company in the UK, and a computer programmer based in the UK is working on a project in tandem with an office, say, in Seattle. The computer programmer H-1B visa was not selected in the random lottery and missed out on an H-1. Now, for those of you who are still waiting to hear back, we haven't received any of the rejections, so there's no news yet in that regard. But let's just say, for argument's sake, this person's did. And they were not selected, and they had to figure out some other way to be in the U.S. to help work on a specific project. Well, they may be able to qualify for the B1 in lieu of H-1B. If they have been, and remember that case that I talked about before, if they have been, if the principal place of business is their employer and their place of employment is abroad, those are important considerations. If they are traditionally or employed by a company, customarily is the term of art, and that usually means they've at least been working there a month, if not longer. Any shorter than a month I've never seen been able to be approved. If they are traditionally or customarily employed by a foreign company that's with the principal place of business abroad and the place of employment is abroad, and importantly, the payroll has to be distributed from abroad. The payroll has to be facilitated from abroad. So if the foreign entity uses a U.S. company to distribute payroll, even for foreign employees, that's not going to work. So they have to be an employee of a foreign company. Then that has to also occur before, during, and after the B1 in lieu of H-1B assignment. So that means that they have to have the intent to return to their home country. This is usually facilitated through a number of ways, but one of which is the support letter from the employer in the UK, for example, saying, you know, so-and-so is expected back to our offices on X date after performing, you know, the very limited and temporary services in the U.S. at this office pursuant to this ongoing project with the company as exhibited by A through G. This person also lives here in the UK, has a family here in the UK, is going to be paid by us throughout the entire period of temporary stay in the U.S., et cetera, et cetera. Moreover, the U.S. company then also will have to demonstrate that all of the requirements of H-1B are met, but for and they qualify for the H-1B, but there are no H-1Bs available in this case, so the B-1 will be used. The Department of State put out a cable last year specifying that even though this may be appropriate, this may have traditionally been used for longer term, and that means with extensions past 6 months, the Department of State cable indicated that it's most appropriate in instances where it will be an activity or assignment in the U.S. for less than 6 months. They even indicated in that specific cable, and I provided a site to it for those of you that are ALA members to be able to find this document, but they specify that individuals who may, on initial entry, appear to have to stay in the U.S. longer than 6 months will not be able to be admitted in that status. So that's an important change and indication that anything beyond 6 months is going to be looked upon with extreme scrutiny. That's more than already the amount of scrutiny looked at with this program. The B-1 in lieu of H-1B, like I said, is a very misunderstood category and underused category. If you have individuals who maybe need to have a short-term transfer to the U.S. in order to perform a very limited set of circumstances or a very limited set of business activities that would otherwise be performed by them in H-1B, but H-1B is not an option, and that temporary stay will be less than 6 months, then the B-1 in lieu of H-1B may be for them. So that being said, similar to the domestic servants situation, if you have individuals in this case, talk to a qualified immigration attorney who's had experience doing these types of visa applications before so that it's done properly and you don't run into any issues or waste anyone's time or money doing half of it right and half of it potentially not right and ending up needing an immigration attorney anyway to fix the situation. The H-3, is in and of itself is a very complex and restrictive type of visa, so that even though it would be maybe for training programs that would be, say, 13 months, 12 months, but absolutely no more than 24 months, that might be appropriate. But maybe if you're just doing a much shorter training program that might be a week or 2 weeks or 3 weeks, or maybe even 5 weeks or 6 weeks, then maybe the B-1 in lieu of H-3 would be the best way to go, rather than jumping through all the hoops created by USCIS. Not to say that any one way to do it is better or more likely to produce a faster result. With a B-1 in lieu of H-3, you have to do a visa application, and I'll get into that specifics of why later with the Department of State, which is any visa application is always subject to potential administrative processing delays. Whereas USCIS, if you did an H-3 petition with them, there is premium processing available, but because it's also already an underutilized visa category, there may not be some familiarity with that, or there just may be the added expense of premium processing fees. Moral of the story is, before I get off topic, these are very specialized types of visas that require experienced immigration counsel to deal with. So if you have any foreign nationals who are looking to qualify under one of these subsets, please contact an immigration attorney. So here again, I just summarized some of the procedural considerations for B-1 business visitors. There's no employment or productive employment allowed in the U.S., but some of these subsets may, whatever they're doing in the U.S. may be considered to be employment for their purposes. And so one example would be the IRS. For tax purposes, what they're doing here or how long they're here. If individuals need to obtain or want to obtain a Social Security card, some of them under B1 status may be able to do so. For example, if a B1 visa is correctly annotated to show that someone is a foreign, domestic, or personal employee of a U.S. citizen who resides abroad, and they have obtained a work authorization document and have managed to figure out how to time all of the applications so that they can work in the U.S. during that temporary period of stay in the U.S. while the U.S. citizen is here. Perhaps they've also stayed long enough where they have to file taxes as a resident for IRS purposes. And just because the IRS says that you're a resident for tax purposes, does not necessarily imply other things. But that means they have to file the taxes, they have to get the Social Security card. They would be able to do so with the properly annotated visa, and the applicable FAM section, and that I listed before, I think it was notes 8 through 11, list the specific subsets. Those are the kinds of things that immigration attorneys can provide to the foreign nationals themselves, for the foreign national on their own, or with competent tax attorney or competent public benefits attorney, be able to obtain the necessary documents for other agencies. And I've talked a lot about the different subsets for B1 business visitors, but I also wanted to highlight, and this has relevance for business visitors as well because of their family members, the B2 subset. This is for pleasure. Well, at least it's supposed to be for pleasure. B2 classification is permissible for individual family members of non-immigrants who, for other reasons, do not qualify as quote-unquote immediate relatives. So, for example, a elderly mother-in-law perhaps would not be able to qualify as an H4 along with her son, who's also an H4, and the wife is the principal H1B. But the elderly grandmother may be able to obtain B2 status, and if the visa is properly annotated as B2 extended family member or other household member, may be able to properly be admitted for the 365 days as opposed to the 6 months, and extend their B2 status indefinitely along with the principal H1B applicant if done the proper way. They still have to extend it in 6-month increments, which can be expensive and time-consuming, and given the fact that sometimes B2 extensions can take 4 to 6 months, may have to be done right away every time that there's an approval. But nonetheless, this is a possibility. We mentioned in passing before the cohabitating partners. That is the Department of State passed in, I believe, and by passed I mean issued, in 2001, they issued a cable stating that cohabitating partners of non-immigrants, meaning perhaps same-sex spouses, same-sex partners of non-immigrants coming to the U.S., since they're not considered for immigration purposes because of DOMA to be able to be immediate relatives, they would be eligible for B2 classification the same way that perhaps the elderly mother-in-law may be able to. So this was one small step for LGBT individuals, or at least same-sex married or partnered individuals of non-immigrants. Back in already 2001, the Department of State had this available. This has been since added to the FAM and is a possibility, and it was initially passed as same-sex or opposite-sex neutral, in that individuals who marriages are not recognized for immigration purposes, regardless of whether they're same or opposite sex, could take advantage of this. But there's very limited other kinds of circumstances where two opposite-sex individuals would not otherwise be able to marry or have their marriage be recognized for U.S. immigration purposes. I'm not saying they don't exist, but this is highly more taken, or rather utilized by same-sex partners or same-sex spouses of non-immigrants. The B2 medical classification is also a highly used subcategory. This is for individuals coming to the U.S. to seek medical treatment. Now, this can be sometimes problematic when thought about or when considered in tandem with the rules regarding admissibility. For those individuals who maybe have diseases of public health significance or may become public charges, they may have some problem being admitted into the U.S. In those instances, whenever it's maybe so extreme that even B2 medical will not be a possibility, or even perhaps B2 extensions might not be a possibility, there may be some humanitarian parole issues or port of entry parole that would allow those people to come in. But for other intents and purposes, if someone is coming into the U.S. for, say, treatment for example, perhaps a eating disorder, and they needed to go to, the U.S.'s world-class institutions and areas and medical facilities that treat these types of infirmities, that is permissible, and extensions in 6 months and 6-month increments are possible. And a final category that I'll cover is for fiancés. Now, this is very difficult because, as Adam covered earlier, you have to demonstrate with the B or ESTA the temporary or non-immigrant intent. You have to overcome immigrant intent. If you're coming into the U.S. to marry a U.S. citizen or green card holder, that's a very big red flag that you have immigrant intent. However, if you can, it's not impossible, and it's overcomable to demonstrate that you still intend to depart the U.S. You just had your heart set on having this marriage in this place, in this gazebo, in this state. Then you're going back to Thailand or the UK or Australia or wherever you're from, and we'll do either immigrant visa processing there, or perhaps you both live abroad. So it's possible in order to come in as a B2 fiancé and then subsequently depart the U.S. as long as you can overcome that intent. It's just harder and more of an uphill battle for those in this situation. This is also possible if you're coming into the U.S. to marry, say, an H-1B non-immigrant. You can show that you have a residence abroad, you have no intent of abandoning, and that you absolutely will maintain non-immigrant intent and will depart the U.S. afterwards, or will seek to change your status to the possible H-4 after marriage. You still have to then demonstrate your single intent. So these are very tricky situations, and you should talk with experienced counsel before engaging any of these special types of subsets. And we get into that because, as I kept mentioning about an annotation on the visa, it's very important that during the initial application for the B1 or B2 visa, that if it's for one of the very small subspecialties we talked about, be it for B1 business activities of very limited or specific scope, or B2 subcategories, that the visa itself is annotated. Why? It's because it lets the CBP officer know ahead of time, or for future visa applicants to show consular officers going forward, that you in fact did present all of this evidence already, and someone has already looked at it and said, yes, absolutely, this is for a B1 in lieu of H-1B. Go ahead and approve it. Or yes, this is absolutely for a B2 medical. Or yes, this is a B2 cohabitating same-sex spouse. Let them in for a year instead of just the 6 months. Things like that. The types of evidence that you would have to show for the B1, B2 visa application, like Adam mentioned already, the 5 principles of overcoming the immigrant intent. This just is a different way of saying them, but the most important, as I've bolded there, is coming with the purpose of engaging in lawful business or pleasure. And that lawful business or pleasure on the one hand, is all those subcategories that we went through that are allowed, but also, more importantly, are lawful. You're not coming in to engage in any criminal activity. And the types of things you're coming in to do, not only are they allowed under that specific subcategory, but are in fact not illegal. Specific duration of time, that goes to temporary intent. Strong ties and having a foreign residence go towards demonstrating what you have abroad and your sufficient funds to that extent as well. Your valid reason for coming to the U.S. is specific to that subset. I will go into the very specifics of annotation in the next slide, but as I mentioned previously as well, the Mexicans with just border crossing cards instead of the visa, who are coming in for NAFTA business visitor purposes, as outlined before, for example, for the after-sales services or for sales or for certain marketing or distribution type of work, they don't necessarily need the visa if they have the border crossing card, but it might be beneficial to have the visa because it will be able to be annotated, and you won't have to bring all this specific, I would bring the specific evidence anyway with you, but you won't have to make the same case as hard if you already have a visa that says specifically annotated on it what that purpose is. For Canadians, it's the same thing. You don't need a visa as a Canadian for B1 entries, but if you had one, it would be nice. So it's a possibility. On the flip side of that, you have to think about the practical implication of a border patrol officer seeing a Canadian with a B1 visa and wondering, well, why do they have a visa? What did they do wrong that they need to have one of those? But that's obviously overcomable. It's just something to consider. So here I go over some of the specifics of what's a good reason to have visa annotation. In some instances, it's not always preferable. And most importantly, it's not also required that they do this, but they should. They should annotate the visa because it's helpful. But as we all know, not all government officials are helpful. So what we can do is try. And one thing to keep in mind that's important is not that consular officials are not permitted to have negative connotations. They're not supposed to say things like, this person is not supposed to adjust status, or they're not supposed to extend their stay. Things like that are not permitted. So if you receive a visa that's annotated in that way, bring it to the attention of your immigration attorney and or the supervising officer at that embassy or consulate abroad. So I've received a few questions, and I've tried to cover most of them as we went along. So if there are some questions, Adam and I will go through and take a look now. I know that we've gone over our time, so we'll try to keep this brief. So there was a question about the B1 in lieu of H1B, which was covered. There were some questions about, again, the PowerPoint presentation. Absolutely, we will be sending that out after we fix it up because, of course, we're both perfectionists, and I think that I've seen at least one or two typos on my end, and I apologize. So we'll send those out afterwards. Let's see. Adam, do you have the access to the questions on your end as well?
I don't think that I do.
Great. So then I will read them on my end. So someone has pointed out, and this is absolutely correct, that the CBP, whenever they initiate the I-94 electronic version, what will occur is they will no longer issue the paper I-94s. Now, they will upon request, or at least they've indicated that they will have some available upon request, but as we all know, again, not necessarily guaranteed that that will be available. So what we suggest for individuals, especially for perhaps Canadians or other people who would like to make sure and double check that they've been entered in the correct status or subcategory, is to request the paper I-94, and even if they don't, immediately upon entry, go to the new website, which we will send out afterwards for the I-94, and print their electronic arrival departure record. The reason we want you to do it as soon as possible is since you're no longer able to verify the electronic information, or rather the official information as reported on the I-94 card before you leave the presence of the consular, or rather the CBP officer, you need to be able to do it as soon as possible from home to make sure that what you have on your travel stamp that's placed into your passport matches what the government has. Because this is very important for a number of reasons. Number one, if they don't match up and you overstay what's on the electronic version rather than what's in your travel stamp, then you may begin to accrue unlawful presence, or at least you'll have the headaches involved with trying to fix that. And I think more importantly, they've also indicated that after you depart the U.S., which will be triggered electronically through flight manifestations or by submitting a paper I-94 back to them upon departure at a land border, will trigger the electronic record to no longer be available. So if you don't print out your electronic arrival departure record as soon as you get into the U.S., it will not be available after you depart the U.S. So it's very important to do this as soon as possible. I'll do one more question, and then we will call it a day since we're already over our time. Let's see. Someone asked about, well, actually, you know what? I just read 3 questions. One about the tour groups, which was covered. One about the musician recording a record in the U.S., which was covered. And let's see. One way, is there a way to extend a B1 in lieu of H1B beyond the 6 months? Well, an extension of B1 can only be granted in 6-month increments. Upon entry to the U.S., while you, before that cable came out from the Department of State, may have had a shot on more than 6 months. Traditionally, 6 months was all they issued, but now it was made clear by that cable the 6 months is pretty much going to be the guiding line, where if there's any indication that it would take more than 6 months, then they will not allow the entry to occur, or issue potentially the visa with the annotation. So in essence, no. If circumstances change, obviously they allow for extensions from within the U.S., but only in 6-month increments. Adam, do you have any final remarks or well wishes for the remaining attendants?
No, other than, thanks for bearing with us. This stuff gets pretty complicated, pretty muddy, and we thank you for your time and your patience. And we are available for additional questions, either by phone or email. Although if you'll give us some time to get to you all, that would be most appreciated. And thanks very much. And it's a beautiful day in New York. I hope it is too wherever you are. And thanks again.
Yes, thank you everyone, and have a great day.